Good afternoon, everybody. Thank you for joining us today for a webinar and conference call discussion regarding the FAR proposed blacklisting regulation and the Department of Labor guidance supporting that regulation. I'm pleased today, this faceless voice that you hear is Eric Conn, and I'm pleased today to be joined by my partner, Kate McMahon, here at Conn Maciel Carey, and our partner in this project, Judy Kramer from Fortney & Scott. We are very pleased to be partnering with Fortney & Scott to serve a broad range of companies and industries in assembling a coalition to improve or possibly eliminate a regulation that will affect government contractors in this country in a significant way. I'm so pleased that you all could join us today. We have had a lot of very interesting discussions with a lot of private employers out there about this rule, and we're excited to assemble this group today to talk about it on a broader scale and to hopefully work with all of you going forward to try and improve a regulation that on its face right now in its proposed form seems to present would appear to be a very burdensome a process that will add significantly to the procurement process and perhaps even eliminate many employers' ability to effectively contract with the government. We have presently muted the other lines during the call to improve the audio quality for everyone, but we will open the audio lines at the end of our discussion about the rule so that we can hear other folks' comments and questions. In the meantime, during the presentation, please don't hesitate to type in a question into the chat area in the bottom left of your screen, and we'll try to address that as we go along. So very quickly, let me tell you who we are if you don't know. Again, my name is Eric Conn. I'm a founding partner and chair of the National OSHA Workplace Safety Practice Group at Conn Maciel Carey. We are a relatively new firm, born less than a year ago, a small boutique firm focused on OSHA and employment issues. Although we are a small firm, our OSHA practice is perhaps one of the deepest benches of OSHA experts in the country. My practice focuses exclusively on workplace safety and health law issues. I work with employers primarily in dealing with inspections, investigations, and enforcement actions, but in the rare occasion that there is an active OSHA-related rulemaking, we get involved and help employers in that regard as well. And certainly what we're dealing with here, although not a rule proposed by the Department of Labor or by OSHA, it really is a OSHA or Department of Labor rule in FAR clothing, and we'll talk a little bit about that as we go through the presentation today. I'll let my co-presenters here and colleagues introduce themselves and talk a little bit about their background relevant to this rule.
Thanks, Eric. This is Judy Kramer. As Eric said, I'm with the law firm of Fortney Scott, and we are pleased to be partnering with Conn Maciel Carey on this effort. We have a very complementary kind of practice to what Eric just described, whereas he is primarily or exclusively an OSHA attorney. Our firm does a whole panoply of other labor and employment laws. We counsel employers on how to comply with the Fair Labor Standards Act, the executive order that requires affirmative action by government contractors in hiring. We work on EEOC matters, and we represent and others as well. And we represent the employers in their audits by these federal enforcement agencies under these various laws. So we are pleased to be working with Eric and Kate on this and putting together some comments, as Eric said, on these regulations, on these proposals that we hope will make them more palatable, if not go away.
And good afternoon to everyone. This is Kate McMahon. As Eric mentioned, Eric and I are with Conn Maciel Carey, and I have spent a good part of my career working in the administrative context, working on rulemakings that will have major impact on our clients, working hard to try to affect change and influence the outcome of the rulemaking to make the end result a more manageable, palatable rule for our clients and employers to handle. I've worked with environmental health and safety people for close to 25 years in that context, and so we're happy to work with Fortney Scott to see if we can have some success here in making this rule, as I think we all just said, either go away or be a much more manageable rule for you to handle if it goes into effect.
All right, so we've scared you a little bit about a rule that needs to go away or be fixed. So let's talk a little bit about what this rule is, or the context of this rule and the guidance. And this is what we're going to review today. Generally speaking, there is a rule that was born out of an executive order, the Fair Pay and Safe Workplaces Executive Order, not fair play, but fair pay executive order. We'll talk about the proposed rules that the FAR Council issued simultaneously with a set of guidance put out by the Department of Labor, and that is what there is an opportunity now until the end of July to comment about. And we'll highlight for you the issues that we see with the rule, the major concerns that we've identified and that many of our clients and other industry stakeholders have identified as well, that we're concerned about with this rule, the things that really our comments will primarily focus on as part of the coalition. And then finally talk a little bit about the strategy that we think makes the most sense for how we influence this rulemaking. It's not just about submitting comments. There's lots of different ways to try and influence the rulemakers and the process itself. I am going to turn over the discussion to Judy to dig into the background about the rule and how we got to this point. She has a deep background with her experience at the Department of Labor, and the folks at Fortney & Scott have been digging into this rule for a good time now.
Thanks, Eric. This is Judy Kramer again. So about a year ago, in July of 2014, President Obama signed the executive order that gives rise to what we're going to be talking about today. And the executive order is called the Fair Pay and Safe Workplaces Executive Order, but known in the contractor community as the Blacklisting Executive Order. And it will become very clear to you shortly why that is, because when you report everything you're required to report under the executive order, you may very well be placed on a list that makes it difficult, if not impossible, to get government contracts. And we will discuss that in greater detail shortly. But the heart of the executive order is that it requires the continuous disclosure of violations. We'll explain what those are, what's considered a violation under this executive order. Violations of 14 listed federal labor laws, and we have those listed, I believe, later on slide number 9, but suffice it to say that it is every major federal labor law that you're familiar with, and then some. So OSHA, obviously, Occupational Safety and Health Act, Title VII of the Civil Rights Act of 1964, which of course prohibits discrimination in employment on account of race, color, religion, sex, or national origin. The Executive Order 11246, which is similar vis-a-vis federal contractors, and not only prohibits discrimination, but requires affirmative action in hiring. The Fair Labor Standards Act, which of course is the minimum wage and overtime requirements. And if you're a government a construction contractor with the federal government or a subcontractor, you'll see on that list DBA, the Davis-Bacon Act, which requires the payment of prevailing wages and fringe benefits. And so there are all those statutes, and then as you'll see on slide 9, that last check mark is for equivalent state laws, and the executive order requires that contractors report violations of all of those federal laws that are listed, and those state laws, the Department of Labor will at some later date designate as being equivalent to these federal laws. So we don't yet know what those are, but there is no question that at a minimum they will be every state's minimum wage and overtime law, and I believe every state has such a law, even if it's just to parrot the requirements of the federal Fair Labor Standards Act. every state's anti-discrimination in hiring or in an employment law will be there, et cetera, et cetera. So at a minimum, I've just named 2 equivalent kinds of state laws, multiply that by 50, and probably the District of Columbia by 51, and you will have another 100 or 104 state laws, the violation of which will be reportable. Not only reportable, but must be reported if you are bidding on a federal contract. So going back to slide number 6, the heart of this executive order is to require this continuous disclosure. And when we say continuous, and again, we'll get into this more a little bit later, at the bidding stage, when you as a prime contractor are bidding on a government contract, or when you as a prime contractor are considering a subcontractor to work on a government contract, you must make disclosures of the various labor law violations that we're about to discuss. And then if you get that government contract or subcontract, you will be required during the life of that contract or subcontract in 6-month intervals to report these violations. So it is continuous indeed. There will also be, and again we'll discuss this in a little bit more detail, the prime contractor will have a duty and obligation to monitor its subcontractors' compliance with labor laws, and in fact to report on the subcontractors' compliance or violation of those labor laws, and therefore you'll need a mechanism if you're the prime to get that information from your subcontractors. Turning to slide 7, the reason for all of this, well, let me put this in context for a second before we discuss the specifics of slide 7. The executive order itself sets out what the philosophy behind the executive order is, and that is, and I'm quoting here from the executive order, contractors that consistently adhere to labor laws are more likely to have workplace practices that enhance productivity and increase the likelihood of timely, predictable, and satisfactory delivery of goods and services to the federal government, unquote. So this is in a procurement context, the theory being that the government, as the purchaser of billions of dollars of goods and services every year, should choose to do decides to do business only with those contractors that are compliant with federal and equivalent state labor laws. And the mechanism for doing this in the procurement process, in the government contracting process, is that in awarding a contract, one of the responsibilities of the contracting officer is to determine whether your company, as a bidder on that government contract, is a responsible contractor, and that's a term of art in procurement law. And one of the elements of being responsible is having demonstrated a history of integrity and business ethics. And that's where these new rules fit in. The theory being that violation of labor laws is a black mark against you in terms of your integrity and business ethics, and that must be taken into account in determining whether you're responsible in the procurement context. The information that you'll be disclosed will be used towards that determination of whether you get the contract. It can be used to determine whether you as a contractor or a subcontractor, should be suspended or debarred. And debarred, again, is a term of art, meaning that you're disqualified, usually for a period of 3 years, from bidding on government contracts, and or the information that's disclosed in the contracting, in the procurement process, in the bidding process, could determine whether you and how you meet the requirements, how you become eligible if you do have a history of violations, how you become eligible to contract with the government despite those violations. Turning to slide 8, we're going to briefly touch a little bit later on 2 really unrelated pieces that don't have to do with what we refer to as blacklisting, don't have to do really with your ability to get or maintain federal contracts or subcontracts. One is called paycheck transparency, which requires contractors and subcontractors with covered contracts and subcontracts to provide certain information on pay stubs to people who work on these contracts. And then also unrelated to the blacklisting, there's a prohibition in the executive order against certain pre-dispute arbitration agreements, and we will explain that in a little bit more detail later on. We've touched on slide number 9 already. That's that list of federal and equivalent state laws that are covered here. So the current state of play, we've got the executive order. We're at slide 10 now. The executive order that was issued a year ago. The FAR Council, and for those of you who may not be into government procurement, the FAR Council, that stands for the Federal Acquisition Regulatory Council, which is made up of the Department of Defense, the General Services Administration, and NASA. Those are the 3 huge government contracting agencies that do the most contracting, and they form a council, and they issue regulations. It's a huge body of regulations that prescribes the clauses that must be inserted into government contracts by the contracting agencies. So what the FAR Council has done is to propose a new set of clauses that will need to be, once this goes into effect, that would be inserted into new contracts issued after the effective date of these rules, or in modifications of existing contracts, and those clauses will have the requirements to disclose all the disclosures that we're about to discuss. But the FAR Council proposed rule is pretty bare bones. It really, the heart of it, the meat on the bones, is in a companion document, a Department of Labor, DOL, proposed guidance, which defines all of the relevant terms that are set out in the executive order. So we will talk about these 2 documents, the FAR Council proposed rule and the DOL proposed guidance, in tandem because they're really inseparable. The FAR Council incorporates by reference the DOL proposed guidance. Once the Department of Labor guidance becomes final, it will become, again by reference, part of the clauses that go into your government contracts. And if you're a prime contractor and you have a covered subcontractor, which we'll talk about shortly, you will have to flow down that clause, insert that clause into your covered subcontracts. This is going through the typical rulemaking process, notice and comment rulemaking, which means that these are proposals. The public has now been put on notice of what the FAR Council and the Department of Labor are proposing, and there is a 60-day comment period, which is a typical length for a comment period, which means that anyone in the public may submit comments on either or both of these documents by July 27th, 2015. So it's at this point only a little bit more than a month away. We know that at least one organization has asked that there be an extension of time. We don't know whether that'll be granted, and if that extension is granted, it probably will be for a fairly short period of time, and the granting or denial of that probably won't be made public until just before the July 27th deadline. So we are working up against an assumed deadline that's coming up in just more than a month. Eric, I'm going to turn it back to you at this point.
All right, so let's get into a little bit of the who, what, and when of this regulation and guidance. The gist of it is this applies to government contractors, prime contractors, and subcontractors. So if you are a prime contractor doing business with a federal executive agency for a contract valued at $500,000 or more for goods or services, this rule applies to you, and we'll talk about what that means in just a second. It also applies to you as a subcontractor or you as a prime contractor who has subcontractors. There's obligations that cut both ways in that regard. A subcontractor is covered by this regulation if the value of the subcontract itself is for $500,000 or more with a covered general contract. There are some exceptions to that, in particular for commercial off-the-shelf items, and we'll talk about that in a little more detail later. The when of this rule, there's a couple of different relevant time periods here, but most important is when do you have to make reports to the contracting officer for the agency that you're bidding on this contract for. There is the initial bidding stage. At the initial bidding stage, you have to report all covered events, and we're going to talk about that in detail, all alleged violations, proven violations, final orders, complaints, judgments across the board. Really the entire life of an enforcement action under these various labor laws are all separately but successive reportable events. So when we talk about timing, you make the report at the initial bidding stage, but what's reportable is all of these events that occurred within the last 3 years. And you might have an event, and I look at this, I put on my OSHA blinders when I think and talk about this rule and say, how do OSHA violations fit into this box? And you've got the OSHA citation. An allegation itself is a reportable event. If you have a OSHA citation that is out there within the last 3 years when you're in the initial bidding stage, you have to report that. If you have appealed or filed a notice of contest to challenge that OSHA citation, and the government files a complaint in that process, and that complaint has been filed within the last 3 years as of the time you're in the initial bidding stage, that complaint is a reportable event. If you have now litigated that event and you've gone through the process and presented your case to an administrative law judge, and the administrative law judge has issued an adjudication on that item, that adjudication becomes a new reportable event. And if that has happened within a 3-year period of when you are in the initial bidding stage, that's a reportable event. If you appeal that ALJ decision and 5, 6, 12 years later we've seen the review commission weighs in and rules on that appeal, that is a new reportable event. Thinking about that, that's going back 12, 13, maybe 14 years after the alleged violation. That is a reportable event for that entire life. And if that has happened, if any of those successive events has occurred during a 3-year period prior to your initial bidding stage, it is reportable to the contracting officer.
If I could just add to that, this is Judy Kramer again. I think that example that Eric just brought up points out one of the real problems we have with this, because if you recall what I said was the underlying philosophy of this executive order was that compliance with labor laws makes you more efficient, your workers are happy or whatever, makes for a better government contract. What's the relationship between a review commission finding today concerning a violation that happened 12 years earlier? What has that got to do with your today's ability to perform under that contract? And that's one of the challenges we're going to make, one of the issues we're going to point out regarding this rule.
Right. So you get past the initial bidding stage, and if you are a contractor who is under serious consideration for the contract itself, you will be moved into the next category, and pre-award there will be an opportunity for you to update your reporting. So if you have new violations that have occurred between the initial bidding stage and sort of the imminent awarding of the contract, there's a new opportunity. I say opportunity, but there's a new obligation to report again. And here, again, those successive issues will be, successive stages of an enforcement action could result in new reporting obligations. And then finally, if you are lucky enough to get this contract and you're going along doing your business with the government, every 6 months during the life of the contract, you have a new reporting obligation. This is wonderful for you all that can't see this on the chat screen. We have a lot of people who have just put in the multiple exclamation points and question marks that allegations. It can't be that an allegation really triggers the reporting obligation, but it does, and that's one of the things that we find, obviously most inappropriate about the rule. Here, an opportunity where even if the rule survives, it certainly makes sense to push hard to have it be a proper reporting obligation, a report of an actual violation, not an alleged violation. Certainly seems to make the most sense. But that takes us right into the next point here about what is reportable. And so what is reportable is, as a first matter, all administrative merits determinations. And when I read this first, this is not a term of art in the OSHA context, and I think this is something they've made up for this rule. And I thought, okay, an administrative merits determination has that finality to it. It makes some sense. But when you read their definition, it is crystal clear that an administrative merits determination includes at least that initial finding by an enforcement agency. And you look at the DOL guidance and they say, well, look, our government administrative merits determinations, our OSHA citations, it's not like a plaintiff's complaint in a civil case, because we've done a substantial investigation and we're responsible, credible folks here at the Department of Labor, so we're not going to put out flawed administrative merits decisions. That's how they distinguish themselves from civil complaints. I think the data does not support their view of their own administrative merits decisions, but the reality is, in this proposed rule, alleged violations, an OSHA citation, which is nothing more than an allegation, is an event that must be reported in this process.
If I could add from another context, Eric has talked about the OSHA context, looking at the wage and hour context for a minute. If any of you have ever dealt with the Wage and Hour Division of the Department of Labor in their enforcement of the Fair Labor Standards Act or the Service Contract Act or the Davis-Bacon Act, you may have gotten a letter, and that's all we're talking about here now, is a letter saying, we, the Wage and Hour Division, have completed our investigation. It is our belief, based on our investigation, that you misclassified one person as exempt from the overtime requirements of the Fair Labor Standards Act, or you misclassified an employee working under the Service Contract Act, Service Contract Act covered contract, or Davis-Bacon Act contract, and you misclassified that person as a laborer step 1 when they should have been a laborer step 2. I mean, it gets as benign as that sometimes. That mere letter saying that the agency found that kind of violation is a reportable event, and it matters not that a year from that letter, you've been able to convince the Wage and Hour Division that, no, you appropriately classified that employee, or you've resolved the matter somehow and it's gone away. That makes no difference. At this point, you report that allegation. It's a finding by the agency, but that's all it is. It's very preliminary. There's been no court or even administrative law judge determination at that point that there's been any violation.
So, that's an interesting nuance to what is reportable and the timing of that, and there's a couple of questions that have come in about that. If there is an alleged violation or a letter setting forth the possibility or the initial finding of a potential unfair labor practice, that is a reportable event. However, if through the contest process or through a litigation process you prevail and that item is completely wiped out, it's withdrawn or it's adjudicated to be wrong in its entirety, then if that adjudication has happened before your reporting obligation kicks in, then you don't have to report it. So, this creates, in a lot of ways, a great incentive to challenge every minor OSHA violation, certainly to challenge alleged unfair labor practices and things like that. But if you challenge the item, you challenge the allegation, and you prevail in the entirety, it becomes unreportable. And if you've reported it, and then in the middle of the contract it gets wiped off your record, you no longer have to report it in the successive or continuous reporting obligation, but it's still out there. They've still seen it. However, if you don't prevail in the entirety, it does continue to be a reportable event because, under the current proposed rule, other than serious violations and fairly minor, trivial, other labor law violations are reportable. So if you are issued a willful violation by OSHA, you challenge it, you litigate, and an ALJ says, well, we disagree that it's a willful violation, but we still think there's a technical violation, so we're going to call it an other than serious violation on your record. That's still a reportable event because other than serious violations are reportable, but we'll talk about in a little bit about what that means. There's an assessment that's being done by the contracting agencies, and other than serious violations are not supposed to affect your ability to contract, but there's a lot of loopholes for the government in that regard as well.
And if I could just mention here, Eric has been talking about what's reportable, and we'll talk about how that's used in the contracting decision about whether you get the contract. But it's reportable to the contracting agency, and one point I want to make here is that the information that you report about the fact that you had a violation goes up on a website that's going to be built by the government, yet to be built. So that information, it doesn't have a lot of detail on it. You're not saying, which employees you allegedly discriminated against or misclassified or had an OSHA violation as to which employees. It's not that specific, but the fact that you've had one of these administrative merits determinations is going to be up on a website, a public website, for your employees, your competitors, plaintiffs' lawyers, unions, the press, anyone who wants to look at that to see. So.
Right. So talking about what must be reported, we've talked about the administrative merits determinations, which includes alleged violations. That's the issue that really jumps out at everybody that reads this rule as, what happened to innocent until proven guilty in this country. This is another step in that direction. If you follow OSHA as obsessively as we do, we've seen this type of movement in a lot of areas. You're familiar with the enforcement press releases that are issued when allegations are made that never get corrected, and no apology ever issues from the government when it's proven wrong. We've seen the severe violator enforcement program where employers are dumped into this bad actor bucket based on allegations. This fits that model very well as well, and following in that trend of we don't care that we haven't proven you actually did anything wrong. We're going to hold you over the barrel anyway. So you've got the alleged violations. You've also got administrative complaints, notices of violation, findings and adjudications of the judicial function within the enforcement agencies or even the independent body of judges for some of the enforcement agencies. All of those steps are reportable events, and they're successive on top of each other. So, again, that's where the trigger comes for the additional how things can go on for years and years and years. The next item here that must be reported, civil judgments related to the various enumerated labor laws. This is where I assume you get into your Title VII type of issues that get into the courts. Those types of events would be reportable events as well. Arbitral awards or decisions based on these 14 enumerated labor laws and statutes as well. And note that the violations are reportable even if the cited conduct or conditions are unrelated to performance of a government contract. And this is an interesting issue and I know a lot of the entities that have dialed into this call today have businesses that span all sorts of, a bunch of different divisions. We've got our government contracting division, our private contracting division. We work in various industries. But these types of violations, even if they were not committed in the furtherance of the performance of a government contract, they can still be used against you in this government contracting setting. So what happens after we report these numerous violations?
I noticed we have a number of questions, Eric, and I just wanted to, this might be a good place to address at least one of them. And somebody was asking whether these are reportable only for Federal Department of Labor, not I can't read all of the question, not a state agency, for example, California. The question's been cut off, I'm sorry, but basically the California agency to be contacted. But since it's not a federal agency, we could exclude that. No, unfortunately, that's still to come. The Labor Department, the Federal Labor Department, U.S. Department of Labor is going in another set of guides, is going to identify the equivalent state laws. And once it does that, presumably there will also be an identification of the state agency merits determinations, so that I presume there'll be something very analogous to what the Federal Wage and Hour Division issues, for example, when it finds a violation, misclassification or whatever of an employee, that if the relevant California agency does that, and of course they have even more stringent requirements for daily overtime and other more liberal kinds of requirements from the point of view of the employee, that when that state agency issues a similar kind of finding, that will be reportable in your federal contracting, your federal procurement process. So this really goes beyond just how good an actor you are in terms of compliance with federal laws, but also whether you have a history a violation of state laws that are still to be identified.
And so to clarify one point about the still to be identified, what has already been identified in the proposed rule are the state OSHA programs.
Yes.
So it's, and that's the only thing that's been identified to this point. So you've got Cal OSHA, Maryland OSHA, Virginia OSHA, all of the state agencies that have been granted authority by federal OSHA to operate a state OSHA enforcement program, and it's about half the states in the country. Those are already in the proposed rule determined to be equivalent state programs. So those violations are at this time, or if this proposed rule went through as presented, would already be reportable labor law violations under this rule. It's the other state equivalents that have not yet been identified and will be, by the Department of Labor at some point after this is implemented. There's another question here about, we are a COTS contractor, am I exempt? And we talked about a COTS subcontractor is exempt, but
Right, this is Judy again. No, there is no exemption for COTS items for general contractors. So as long as you have a contract that exceeds $500,000, that's a covered contract, and you'll be required to make all these disclosures that we're discussing, even if you're a COTS provider. But as a subcontractor, if you provide COTS items, and that's broadly defined under the FAR, as goods or services. So if you're providing COTS goods or services, there is an exemption for that, and you would not have to make these disclosures.
And that's commercial off the shelf.
Right. So in other words, if you're providing exactly the same sort of good or service that you provide to the government that you provide to commercial customers, you are exempt from these disclosure requirements. But if you modify your product or your service, you produce airplanes for the government, for the Defense Department, whatever, and that are different from airplanes you provide to United Airlines, those are not COTS items, and those are not exempt.
All right.
So this is Kate McMahon, and what I want to have a focus on now for a few minutes anyway is what happens next. Judy and Eric described sort of the philosophy of the executive order and how the Department of Labor and FAR Council is attempting to implement the executive order. The first step, of course, is this disclosure requirement that will broadly apply to contractors and subcontractors. Then the question is, okay, all this data, all this information is disclosed pursuant to the regulation. What happens next? How does the government make this responsibility determination? The philosophy behind the rule sounds, at least at first glance, like a laudable one, right? We want our government contractors to be responsible parties. We want to incent contracting with responsible parties. However, the real problem with this regulation as drafted and the guidance that supports the regulation is how the government intends to make that determination. The plan, according to the proposal and the guidance issued, is that they will focus, of all the disclosures that are obtained, they will focus on those violations that are most concerning and have the greatest bearing on an assessment of a contractor's integrity and business ethics. So far, so good, right? However, what they've done in the regulation is they've identified how they will make that focus and what that focus will be. What they have indicated is that they will focus on those violations that are characterized as serious, willful, repeated, pervasive. Now, again, at first glance, and if you're a layman and don't know much about how those terms of art are used in the legal context, that too sounds like, okay, that's a legitimate focus. The problem comes in when you understand how those terms are defined under current statutes, because the agency will adopt the statutory language where it exists. And the rule makes that clear. So, for instance, and I'd say probably most troubling, included within the focus in making this responsibility determination will be serious violations. That is violations that are characterized as serious. If you look in the OSHA context, serious violations, as probably many of you on the phone know, are they're ubiquitous. They are the go-to citation that the agency issues. The data from 2009 to 2013 that we looked at show that 75% of all OSHA citations issued are serious, and then on top of that, another 5% or so are either willful or repeat. And so, all told, you're dealing with the huge majority of OSHA citations fitting within the definition of those violations that will be the focus of the concern in making this responsibility determination. So, while the concept makes sense, the implementation, at least as currently drafted, makes no sense whatsoever. It will not achieve the goal that the agency has set out to achieve, and it will pull a huge percentage of responsible government contractors into the sort of danger zone of being, having the contract not obtained or retained. So serious violations, in addition to including those violations that are identified as serious under the statutory frameworks that are at issue here, also include violations which have a fine or penalty of $5,000, of exceeding $5,000. So if you apply this to the OSHA context, you could actually conceivably have other than serious citations that total over $5,000 that would put you in the trouble zone. And other than serious violations, as you all may know, are minor paperwork, extremely de minimis type citations. That would be included. Similarly, back wage awards of $10,000 or more, and or violations where there's an imposition of injunctive relief. For instance, in the whistleblower context, there may be relief that imposes, reinstates an employee. That automatically will trigger you going into this category of troubling violations. Another item that we wanted to at least bring to your attention is this interference with the investigation. If it looks as if the contractor has taken action that interferes with the agency, the enforcement agency's investigation into the underlying citation, that will put you in this trouble zone. The problem with that, of course, is an employer may exercise the rights that he has every right to exercise, for instance, asking for a warrant before an inspection or challenging a subpoena to a document request. Those actions may, in fact, trigger this interference with investigation factor, and you will be thrown into the trouble zone. In addition to serious violations, willful, repeat, and pervasive, I won't go through those because time is short here, but we've defined on slide number 16 the meat of what is intended by willful, repeat, and pervasive. Willful and repeated, as those of you who practice in the OSHA area or deal with OSHA citations know, are categorizations that are specifically recognized by OSHA, and the FAR regulation adopts the same definitions that are used in the OSHA context for willful and repeat. Pervasive is a new term. It is not something used in the OSHA context, and I don't think used in the other labor law context either.
That's correct.
So the agency is currently defined anyway as violations that reflect a basic disregard by contractors of labor laws demonstrated by a pattern of serious or willful violations, continuing violations, or numerous violations. But as you can imagine, without more, it looks as if that could at least reasonably include, let's say, multiple other than serious OSHA citations. If you have a number of paperwork violations, for instance, record-keeping violations, that are, in the scheme of things, very low fines, not troubling, easily fixed, and don't pose a danger to your workforce, those could be cumulated and considered pervasive under this terminology.
The DOL guidance offers some comfort here and says one violation will not necessarily be considered pervasive. So,
so sit down, don't worry. Right? How often do you get a citation that includes only one violation? It doesn't happen often. So this slide here, slide 17, is really just to sort of bring home what the problem is with the regulation as currently proposed. The consequence of going through this determination, this responsibility determination, is extremely severe. Anything from the rejection of the current bid upon which you're bidding, to a rescission of an existing contract, to a recommended debarment. So you may end up being put into debarment proceedings based on the reporting that is done under this regulation. And finally, and we want to spend some time talking about this, the framework of this regulation seems to provide an opportunity for a contractor who may be reporting violations to address those sufficient to, retain or obtain the contract. But that's a very troubling part of this framework, because what it allows for is mitigating circumstances to be considered when contracting officers are considering the responsibility of these contractors and making this evaluation. So there's going to be undue pressure, we're concerned, put on the contracting officer to remediate the identified issue. Well, the unidentified issue may be being litigated on a separate course by that contractor. So you may be in the process of litigating and ultimately prevail in that litigation, or reach a settlement with the government that would impose the specific terms that you have to abide by to settle the matter. Meanwhile, on a separate course, and presumably a quicker course, you may be sort of de facto pressured into remediating the alleged violation sufficient to, retain the contract. And we don't know what that means, because the contracting officer, in conjunction with a newly created position, an agency labor compliance advisor, will make the assessment as to whether the remediation that you might want to offer up is sufficient to make you feel pretty comfortable that you have taken an action that will save your contract.
And this is really that issue, the labor compliance agreement, or identify your remediation measures. That issue, in conjunction with the idea that allegations, trigger all these negative consequences, are what raise all the red flags to me, and I know a lot of people we've talked to about this. That's where you get into the idea that due process has gone out the window, and that the government is compelling a punitive element without having proven that you did anything wrong. And if you're in a position where you are obligated to abate a violation that may not actually be a violation, Congress looked at that, and when they developed the OSHA Act, and they said, no, we are going to stay the obligation for employers to abate violations until a final order, until either the employer has accepted responsibility for the violation or it's been adjudicated that there was an actual violation. The notion here is that you will not be eligible for government contracts unless you abate violations, even though you've contested them. And then the labor compliance agreement, we'll talk about that in some more detail. To me, that is a step further, that unless you do something that the law doesn't require, that whatever it is that the enforcement agency wants you to do, you won't be eligible to contract with the government. And to me, I see that as a wide open backdoor for all the rules that OSHA and these other agencies have tried to promulgate but haven't been able to. Well, we can force our government contracts to do them, or contractors to do them, if they want to do business with us. And that's what I think is going to happen there.
So the way this works, at least as currently proposed, is that this newly appointed position at the contracting agency, an agency labor compliance advisor, will work with the contracting officer to assess the identified violations, the disclosed information that you all have provided, and then make a determination as to whether remedial measures are necessary. One of the mechanisms that this rule provides is that it may be that the ALCA advises the contractor to enter into what is called a labor compliance agreement. And that agreement will set forth the terms of your remediation. So between the ALCA and the contracting officer, they may essentially write what what would be in a different context a settlement agreement, but these people are not trained even in the underlying statutory framework or requirements of the labor laws. So they will be making determinations about what your remediation should be, and that will then be incorporated into these labor compliance agreements. And as Eric mentioned, the concern is that no holds barred, anything goes. So let's say that the Department of Labor believes that an I-2P2 program would be very helpful to this contracting entity to keep it from violating future labor laws, that or the OSHA Act. That may be incorporated into a labor compliance agreement and obviously otherwise not required under the law.
I'd like to add here, this is Judy again, one other feature that we really haven't focused on here, and that is, as Kate just described, there will be these agency labor compliance advisors in each of the contracting agencies. Well, the Department of Labor will have an analogous staff of people, and they've asked in the budget process for enough money to fund about 25 or 30 such positions. And so the role of these advisors is going to be to advise the labor advisors in each of the contracting agencies, and apparently to give compliance assistance to contractors and subcontractors. And there's a footnote in the Department of Labor's proposed guidance that says that contractors and subcontractors before bidding will also be offered the opportunity to receive early guidance from the department and other enforcement agencies on whether any of their violations of the labor laws are potentially problematic, as well as the opportunity to remedy any problems. So there's another opportunity to come into some sort of labor compliance agreement, but also to go to the Department of Labor, which will undoubtedly use that information to perhaps open a new audit of you or your subcontractors if you're a prime. There's no indication here of any sort of safe harbor. If you go to the IRS and ask for assistance to have them give you an opinion as to whether you should report certain income, they will tell you that, and they will not open an audit of you just because you ask that question. There is no such guarantee here, no such assurance at all by the Labor Department, and instead we're fairly certain from talking to people at the Department of Labor that this will be another avenue for information that will enable the agency and other enforcement agencies to start new investigations.
Yeah, and or to force you to undertake efforts that are not required by the law. I mean, to me, that's sort of the obvious path here. I can hardly imagine going to OSHA and saying, we're about to bid on a government contract. Do you think my OSHA record is problematic? And that their answer is going to be no. Right? If there's anything on there, they're going to say, well, it could be. We encourage you to implement an I-2P2 program, develop an ergonomics program, put in place a heat illness program, all of these things that, this is the graveyard of failed rulemakings that OSHA gets to now require you to undertake as part of this process. So, I mean, we've talked about it, but to me, that's my big concern here is that this labor compliance agreement, this agency labor compliance advisor arrangement is a backdoor opportunity to require things that could not be required before. And we talked about how these folks could not possibly have enough knowledge, experience in these labor laws to really be the right people to adjudicate in a outside of the normal context. And we're not casting dispersions on those people. I mean, you could bring in the former Assistant Secretary of Labor for OSHA as your ALCA over at NASA, and he's incredibly knowledgeable about OSHA, but there's 13 other labor laws that he's also going to be making determinations about as to whether violations are serious and should result in you not being able to bid on a contract. So this ALCA position, I think, necessarily is, puts somebody in a position to make a determination that they're not equipped to make. And that presents a problem, especially when you're dealing with substantial contracts like this. And we've talked about the labor compliance agreement in pretty good detail here. To me, this is the thing that scares me the most. It's a brand new term. It was invented for this regulation, and this is what has kept me up at night thinking about what these labor compliance agreements look like. Because think about when you're sitting down across the table, in my practice with OSHA to negotiate a settlement agreement over a specific violation. We're going to talk about whether there's substantive merit to the violation, and we both have leverage when we're sitting at that table. I've got the facts and the law. They've got their positions, and at the end of the day, we can go before a judge if we are at an impasse. In this circumstance, they're holding you over the barrel and threatening to withhold, a $1 billion government contract unless you agree to their terms, and you have no leverage in that circumstance. So it's a dangerous new tool that the Department of Labor will acquire with this regulation. So we'll talk about subcontractors in a little more detail.
Yeah, well, we've touched on most of this. The same threshold applies. So if you're trying to become a subcontractor, or if you as a prime are trying to bring a subcontractor in as part of your contracting plan, the same threshold, exceeding $500,000. If the subcontract exceeds $500,000, that your subcontractors or you as a subcontractor make those same disclosures. The exception, as I mentioned earlier, that applies only to subcontractors, and I apologize if I wasn't clear about that before. The exception is for subcontractors only, not primes, but subcontractors that provide commercial off-the-shelf or COTS items. So those would be exempt from the disclosure requirement. As proposed, the subcontractor would report up to the general contractor, the prime contractor, and the prime would make that same kind of assessment as to responsibility. In other words, the prime would look at the sub's disclosures of all of its labor law violations at the federal and state level and determine how serious they are, how pervasive they are, et cetera, and determine whether this is a responsible subcontractor. The proposals suggest that in commenting on these proposals, commenters might also comment on an alternative means of disclosing this information, and that would be that the subcontractor, the potential subcontractor, make these disclosures to the Department of Labor for it to make that determination of the subcontractor's responsibility. So we've kind of gone back and forth. I think probably most contractors that I've spoken to would not want that disclosure made to the Department of Labor. They'd rather do it themselves, make that assessment themselves of their subcontractors. But this brings up a broader issue. For the general contractor itself, the prime contractor, think how hard this is going to be to report on all of your own violations, especially since you have to go back 3 years. And until this reg goes into effect, this regulation, there's no requirement to keep that information, to have a database where you keep track of your violations going back 3 years. But you're going to have to build such a database going forward so that you can, with some assurance, certify to the contracting officer that you fully and accurately reported all of your violations, or the fact that you have no violations. And that's very risky. It's highly unlikely that any large company or even most small companies will be able to capture every relatively small OSHA citation or wage and hour finding issued during the previous 3-year period. And then think about having to assure that your subcontractors make the correct disclosures to you, the prime contractor, so that you can make the appropriate disclosures to the contracting agency. So in addition to in addition to the burdens that we've identified, it really subjects everybody to risks of false claims allegations. If you're certifying something in good faith that you thought was accurate, but it turns out that you missed a violation or a subcontractor missed a violation, that could be very serious. Sorry.
There's a question that was presented in the chat area that is relevant to what you just described, sort of this process of how we're going to capture all this. And the question was, is there a government tool that will be populated to contain all this information? That's one question. And then I think separately, as a separate question, is will we have to populate it for every contract, or will there be, if we have multiple contracts that we're bidding on as the prime, will that information be preserved somewhere? To the first question, I mean, that you would think the government has much better access to this information than you do, but the expectation is that you as the employer, or you as the bidder, are going to have to go back through your own record and pull all of this material together. There's not a tool that the government has that has this information pre-populated or accessible or searchable, but once you will have an obligation to enter it into some system. And then I'm not sure, if it's, I assume it's preserved and you can access again. It doesn't exist yet, so we don't know.
Right, and there isn't any. It might be a good idea to propose that there be a tool, some sort of blank form that the government comes up with that you populate, but they have not proposed such a tool. And yes, it is done for each contract. So it may be because you may be on different cycles as well. Right. So you're bidding today on a contract, making your disclosures going back from today back 3 years, and then you're bidding a month from now on another contract, different time period, going back today to a 3-year period. And during the life of each contract, presumably, and this is not clear in the regulations, but I'm guessing that the most natural reading is that during the life of the contract, it's every 6 months of that contract. So that if you get a contract in June, you report again in December on you make disclosures about your violations going back 3 years, and then again next June. And if the contract is renewed, if the government exercises an option to renew a contract, 6 months after that, 6 months after that. But if you get a contract in September, your reporting is in March, September, etc. So assuming you have multiple contracts, you could be making these disclosures continually.
Another issue that we wanted to at least bring to your attention is, this question about what is the responsibility of the contractor, the general contractor, as to this information that is disclosed related to its subs. There's this mechanical question of how do you gather this information, but there's also a question about what if once you gather the information, as the rule is currently written, you as the contractor will be making the responsibility determination. You are put in the shoes of the contracting officer at the agency. You will be making the same determination it will make about you. And query what happens if in the eyes of the agency that you're contracting with, you made the wrong decision, or in DOL, in the Department of Labor's view, you made the wrong decision. There were disclosures from your sub. You went ahead and retained that sub anyway. What consequences are there? And I think that's not addressed in the rule at all at this point.
There's also an issue for large companies that have multiple business units. What if only one of those units enters into a contract with a government agency? Does that business unit have to report the violations of its sister business units that aren't involved in that government contract? And will the violations of that sister business unit be held against, in the procurement process, be held against the business unit that does have a government contract, and vice versa? Those are unanswered questions, and we'll talk in a minute about our strategy for writing comments, but that's one of the unanswered questions that we hope to steer in the right direction in terms of getting an answer. Okay, and as I mentioned earlier, we're not going to dwell on these because these are really unrelated to the heart of the executive order and these proposals. The first is paycheck transparency, and basically what this requires is that each pay period, the contractor would have to provide on the pay stub to everyone working on a covered government contract certain information regarding hours worked, overtime hours, and pay, et cetera. This is all information that you're required to keep anyway, but now you would have to put it on a pay stub so that the employees, the workers, can see the information. For those of you who have employees in California, you're probably already required to put a lot of this information on California pay stubs, and the proposal makes it clear that if you're complying with state laws that require this information be put on pay stubs, you'll be okay. You will also have to put in writing for those employees that you have classified as exempt from the overtime requirements of the Fair Labor Standards Act, the fact that you have classified them as exempt. And then the last bullet point is the only one that gives us some pause because it's not clear what's going to happen here, and that is if you have workers that you have classified as independent contractors as opposed to employees, so 1099 workers as opposed to W-2 employees, that you're going to have to let that independent contractor know in writing prior to beginning work that he or she is an independent contractor and therefore not entitled to a lot of protections of the federal labor laws. And that's clear enough, I think, that let's say you're a tech company and you hire a consultant to build some new database for you, and it's clear you have an employment agreement and you pay that person as a 1099, and you've correctly said you're not our employee, you're our independent contractor. Okay, you notify that person that they're an independent contractor. But we also have many, many clients who use temporary workers supplied by labor supply agencies, by temp agencies, and those are W-2 employees vis-a-vis the temp agency, but they're not your W-2 employee. They're somebody else's, and it's not clear whether you have to, every time you use one of these temp employees, let that worker know that you consider them an independent contractor. Again, the better answer will be no. You don't have to do that, but the proposal is not clear on that point. And then on slide 22, the other, again, unrelated to blacklisting provision here is that for contracts, and here the threshold's higher, if you have a contract that exceeds $1 million rather than $500,000, but for only those contracts exceeding $1 million, you cannot require that your employees arbitrate their Title VII claims against you or their claims having to do with sexual assault or sexual harassment. So these are pre-dispute arbitration agreements, meaning that it's sort of a blanket agreement before any issue arises that you require the employee to submit any future claims that arise to arbitration. Those are prohibited. We have no idea what the connection there is to government contracting. They just threw this in. There are exceptions where there's a collective bargaining agreement that provides for arbitration, and there is also an exception for commercial items. And you might note there that's not COTS. It's not commercial off-the-shelf items. It's commercial items, which is a little broader than COTS. So there are some exceptions here, and it doesn't bar arbitration agreements that are entered into after the dispute arises. So an employee says, I have a complaint against you under Title VII. I believe you discriminated against me on account of my race, color, religion, sex, or national origin. And if the employee then says, okay, I'll agree with you that we'll go through arbitration or some sort of mediation or whatever, instead of going to court, that's okay. So that, and I know that some employers are troubled by that because they do have arbitration agreements, and this is of concern to some clients.
So that sort of, we've walked through the major provisions of the proposed rule and the guidance now. We have a handful of slides here about what, were the big red flags to us. And we've talked about most of these already. Just as we start talking about the provision, it's hard to resist the impulse to talk about what's wrong with it. So we've done a lot of this already. So we'll be brief in this part so we can open it up to some more questions if you have them, and to get you on your way, because we've been at this for a little while. This slide talks about the issue, the major issue that everybody reacts when they see this is that, wait a second, how can this be based on allegations? There's a lot of different elements to this what I see as a due process issue. Allegations are covered. There's all sorts of negative consequences based on unproven allegations. But there's also elements of due process here that we haven't talked about that I think are problematic, and that is that your ALCA, your agency labor compliance advisor, and the corresponding enforcement agency that issued the citations are now sitting in the judgment seat. They are going to make a decision about whether their own alleged violation is legitimate and therefore should have a consequence as a result. I mean, how could they ever conclude that it's not a legitimate citation that they themselves have issued? They're going to go to OSHA and say, hey, is this serious, and is it correct, and have they remediated it? It puts the accuser in the judge's seat as well. So I think that's a due process problem as well. And of course, abatement being required before violations are proven, requiring rules that have not been enacted, requiring those obligations on employers. All of that is problematic. And then there's this issue that I think is a little quirky, where you're guilty even after proven innocent, where if OSHA has alleged you're a willful violator, but you litigate, adjudication by a judge says, well, you're wrong, OSHA, this is an other than serious violation, that's still something you have to report, and it's going to be sitting out there, with the contracting officer going back to OSHA or one of the other enforcement agencies saying, is this a serious violation? OSHA surely doesn't agree with the judge, and they're going to get to weigh in whether it should affect your responsibility determination. So even after you've proven OSHA wrong, it's still reportable, and there's still that interaction that will happen between the ALCA, the contracting officer, the ALCA, and the enforcement agency.
Another interesting concern that we have is the way that these proposals work together. As I think we mentioned at the outset, there's a FAR proposed regulation. There's also proposed guidance from the Department of Labor. The Department of Labor has put this forward for comment, at least in this first instance. But the way these two things coordinate with each other and interface is that the guidance document from the Department of Labor is incorporated by reference in large measure in the regulation. So once finalized, if Department of Labor changes its guidance, then the regulation presumably changes with it. And there's no opportunity in the future that has been identified anyway to comment or go through sort of the Administrative Procedures Act process for commenting on and participating in revisions to the guidance. So, it seems to violate the APA by incorporating the guidance into the regulation.
And maybe this fits into the new model, the post-mortgage bankers universe that we live in, where the agencies feel like, well, we don't need to do rulemaking. These are just interpretive rules. But the guidance is really the meat of the regulation. The regulation lays out an outline, and the Department of Labor fills it in with all of these terrible things we've been talking about today.
Looking at slide number 25, we've talked about much of this, what we've identified as separation of powers. I'll just mention briefly. And what we're talking about there is that through rulemaking, the executive branch seems to be providing for remedies under federal laws, which of course are enacted only by Congress, to provide some remedies that Congress never contemplated. So they're really amending these statutes. For example, the Fair Labor Standards Act, the remedy is you pay back wages to employees that you haven't paid overtime to, for example. But there's nothing in the Fair Labor Standards Act that says you can get debarred from government contracts. And that's what could happen because of violations of the Fair Labor Standards Act under this. And you could say that about every one of these federal laws, not with the exception of the Service Contract Act and the Davis-Bacon Act, which do provide for debarment. None of the others are related to your ability to get government contracts, yet this provides that additional remedy. We've talked about the unreasonable look-back period, how it's not really related to your present ability or integrity under government contracts. And then, of course, in addition to all of the legal and constitutional issues we've identified, really the heart of our concerns are the unreasonable burdens, the practical impossibility of providing all of this information and certifying that you're doing it accurately. The way that this will bog down the procurement process. This is supposed to be helping the procurement process by ensuring that the government only contracts with the good guys, but it's really adding a lot of time and burden to contracting agencies and contractors, and therefore the public at large, and adding a lot of cost to all of those entities.
And the irony is, if you look at the next slide, it won't even, meet the goal that it has identified of ferreting out the bad guys, because it's so over-inclusive. It will include, the large majority of contractors will be responsible contractors who have had some, in the past, say decades, some labor law violation that won't necessarily relate to whether it is a company that has integrity and business ethics and therefore ought to be awarded a government contract.
And in fact, in sort of the preamble to these proposals, before you get into the meat of them, the FAR Council and the Department of Labor say very explicitly that most contractors are trying to comply with the law. It's only a few bad actors who ruin it for everybody. So they're using a sledgehammer here to get at the couple of small fleas that are corrupting the process, and it's really, really not related to the underlying philosophy of the executive order.
And, that might be a good segue into the question of, okay, so, what do we do here? Because, we think that there are numerous bases for essentially a wholesale challenge to this regulation and the guidance. We've mentioned a number of the concerns that we have that are, constitutional in nature. There may well be a serious separation of powers issue as well as a substantive and procedural due process issue with the regulation as currently written anyway. So we think it's important to identify those concerns and raise in the process that is afforded to us as impacted stakeholders the concerns. In addition, though, we think that, there is some basis for the executive order objective, which is to identify, to do a responsibility analysis that focuses on the integrity and business ethics of a company. And so if the rule could be scoped in a way, and this would be a dramatic revision to the current proposal, but if the rule could be scoped in a way that met that objective, that is, that did ferret out the bad guys and didn't impact or overburden the responsible contractors, then that ought to also be raised in the context of the comments that will be submitted, or the context more broadly of the rulemaking process. The next stage, of course, is which is the development of written comments that will be submitted to the record by or before July 27th. So, I think maybe we wanted to spend the last couple minutes talking about the strategy that we would recommend for going forward. This rule is too significant to let, someone else take care of. We understand there will be trade associations commenting, and the major industry associations certainly will comment on this. We think that or may comment on this. We think, though, that Eric has pointed out that this is a very busy time. It's the end of the administration. Rules are coming out on all fronts. And so, one thing that's happened we're concerned about is that this rule sort of got lost in the mix. And so we want to take, we've put this, we're attempting to put a coalition here in order to address the rule so it isn't lost in the mix. And we want to talk to you further about how we address it most effectively. So, we've got a couple of minutes left. Maybe should we open it up to comments and a discussion about how to proceed? We think that written comments are necessary, if for no other reason, to build a record upon which a legal challenge can be brought if the rule is promulgated, but also in a real, authentic effort to narrow the scope of this rule and to fix it so it meets the identified objective in the executive order, if possible.
All right, so I'm going to unmute some lines.
The conference has been unmuted. The conference has been unmuted.
We've had a lot of questions come in through the chat box, and we've tried to address those throughout. But if anybody's out there has comments, questions, ideas, we're open. So let's hear what you all have to say about this. And I don't want to hear any snoring. Now that I've unmuted it, if I find out you're all sleeping, I'm going to be self-conscious. So anybody have any thoughts or questions online?
Eric, this is Stephen Lee. Can you hear me?
Yes. Hi, Stephen.
Hey, Eric. Thanks for doing this. Just had a question about outreach to members of Congress. Is that something that you guys have undertaken or are thinking about, or is there, are there particular, if you were to do that, what would be sort of who are some of the members perhaps or committees that you might think about approaching?
Stephen, this is Kate McMahon. First of all, yeah, I mean, we put on one of the last slides in the pack there. We identified the major components of a rulemaking strategy that we would like to unfold on behalf of our clients, Fortney Scott's clients, and this coalition that will be put together over the next week or so. As we pointed out, that we're already at the proposed rule stage. So what we're sort of stuck with is the next opportunity we have to impact this rule in a significant way is the submission of comments. Now, there's a lot of question about whether the comments have any meaning at all to the agency that we submit them to, but it's a step it's a mandatory step that must be implemented. But beyond that, we have, in fact, identified a legislative strategy that we would like to build as a component of our overall efforts to impact the outcome of this rule. And I think it's probably a little premature to identify which members we would focus on, but, the committees are obvious. The committees that impact, the labor community. And so I think both on, on the House as well as the Senate side, we would focus on, I think there's an opportunity to focus on both Democratic and Republican members, because I think the Democratic members will want to be engaged here to make sure that this rule does what the executive order is designed to do. And certainly I think the Republican members will recognize immediately the overreach of this rule as proposed. So yes, there'd be a legislative strategy. We would be hopeful to have interface with the Department of Labor and with OMB and the White House to talk about what the legal concerns are about the way the rule is written, as well as how to scope and narrow the rule to be effective.
Great, thank you.
I'm looking through to see if there's any other questions that were typed in as we went along.
One of the points we want to make before we end here, I think is an important one in terms of, and it relates to process. Right now, as Judy pointed out at the outset, we have this July 27th deadline. We don't know whether the agency will grant an extension or not. Even if an extension is granted, we might not know about it until very close to the July 27th date. So we have to proceed in assuming that deadline is a valid one. And that means that we have just a very short time here to, sort of have this coalition coalesce in order to develop effective comments on behalf of the members of the coalition. So we're going to move forward immediately, and we will reach out to those of you who are interested, and we hope it's most of you, to sort of make the final determination about who the coalition will include and what the key priorities will be of the coalition. Obviously, as lawyers who work in this area and arena every day, we can also work with you individually or with your trade association in your specific industry to focus on specific issues of concern to your industry. But we think there's probably a place to do both. That is, to work with specific industries as well as to build a multi-industry coalition to submit a broad comment across the bases that we've identified here.
Right, and we do, we contemplate different paths for different employers, different industries, different association groups, because as this is not the typical situation where it's a single safety issue that's being raised in a rulemaking where everyone's generally looking at it with the same concern. This is an incredibly broad rule that has incredibly broad application and will impact lots of different segments of your business. And what's interesting about it is, we sat down, Fortney and Scott and Conn Maciel Carey separately and said, what are the big issues here? And we came up with such a substantial list, A, because we think the rule is really poorly crafted, but B, because of the broad impact of the rule. And this could be a situation where, there may be a group out there that's commenting on this, but they may not be focused on your issue, or your issue may be lost in the shuffle among the many, many issues that are problematic in this rule. And that's why what we're doing, I think, presents a good opportunity for everybody to make sure their voice is heard and not lost. So we definitely encourage you to participate. Our contact information is up here on the slide. I'm afraid to say we're going to pester you one way or the other. Since you've signed up here, you'll hear from us. We're happy to share this information with you in case there's others at your company or your association or your member companies that have interest in this. We'll make sure you've got a copy of the slides and the recording of this discussion. But we're moving forward. We hope to have a pretty solid set of list of employers and companies and associations who are part of our group by what do we say, the 30th is our target there. So please let us know as soon as you can if this is something you're interested in, or if you have other questions. And I know that there's not a lot of interest in voicing perhaps some of your own hypothetical situations about whether something is a violation, a covered violation, what it might mean for your contract bids on a public discussion like this. So please feel free to call us, feel free to shoot us an email, and we will have those offline discussions about this. But, I think this is a critical rule, and I think it has the potential to be lost in the shuffle. There's a lot of rulemaking exhaustion that goes on at the end of an administration that's trying to force through all the things they promised to do 8 years ago. Well, this is something that we've not seen highlighted by many of the trade associations out there, and that's why we've stepped in to hopefully fill that void and make sure that something as critical as this and as impactful as this does not slide through without industry stakeholders being heard. Yeah. So we hope it's important to you and that you join up with us.
And obviously, it probably goes without saying, but the broader the coalition and the more well represented it is across industry segments, the more influence its comment will have. And so we encourage you to consider supporting an effort that would result in the submission of comments, and then all the activities that we would identify for a comprehensive rulemaking strategy that would unfold after the submission of the written comments.
And I would just add to that, and I thank you all for participating today, and Eric and Kate for including me in this excellent webinar. That I would just want to emphasize that for the coalition members, our strategy would be to file comments, to submit comments under our law firm's name, so that individual members of the coalition, unless you wanted to be identified, would remain anonymous. You don't have to stick your hand up and say, I have violated the labor laws, and how is that going to impact me in my government procurement. We anticipate describing in generic terms the industries that make up the coalition, but any individual member of that coalition could remain anonymous.
Well, thank you, everybody. I'm going to stop the recording, and we'll be in touch very soon. But you don't have to wait for a call from us. We'll look forward to hearing from you as well. Thanks for joining us.